no better time to start working on your data. And tonight we have created a fabulous panel from both America and locally. Let me introduce you to the chair of today, Justice Margaret Beazley. Justice Beazley was admitted to the New South Wales Bar in 1975 and was appointed a QC in '89. She became a judge in the Federal Court of Australia in '93, and 3 years later, she became the first woman appointed to the New South Wales Court of Appeal. Last year, in 2013, Her Honour was made the President of the Court of Appeal, and I will leave her explain a little bit more about herself in due course. Judge Peck was appointed a United States Magistrate Judge for the Southern District of New York in '95. He served as Chief Magistrate Judge from 2004 to 2005 and has ruled on landmark cases, including the De Silva Moore case on the use of predictive coding. Also on our panel is Jason Barron. Jason is of counsel to the Information and e.Discovery group of Drinker, Biddle and Reath, and co-chair of the Information Governance Initiative. Jason previously served as Director of Litigation for the US National Archives and Records Administration. And before that, he was a trial attorney and senior counsel to the US DOJ, Department of Justice. Alison Stanfield, founder and CEO of eDiscovery, and is one of those friends of Nuix I mentioned. As most people know, e.law provides eDiscovery and e-trial services to law firms and corporations throughout Australia. And finally, Stephen Stewart, Chief Technology Officer in Nuix. We fooled Stephen many years ago in telling him that we had 50 people when he joined, and that was 6 years ago. We had 15.
Morgan expressed it that there were less than 50. He wasn't very specific as how much less than 50.
We're now well over 200, but at that stage, that was he never asked the right questions. Stephen actually has been responsible for starting and completing the largest ever eDiscovery case that I know of, and indeed it's also became the biggest defensible deletion project ever undertaken to my knowledge. It involved 3.1 billion emails, 460 million Word documents, 330 million Excel files, and an awful lot more. So don't hesitate to ask him what a headache that was after this. With that, please welcome our panel.
So I'm going to ask this question of Judge Peck. We've been hearing about big data. So how big is the big data problem? And when we ask that question, where does that come in and impacting on companies when it comes to litigation, which, as I said, is really a retrospective look at things that have occurred?
Big can be very, very big. As Eddie said, talking about the litigation Stephen was involved in, I mean, that's bigger than anything I've heard of. But it is not uncommon in litigation in the United States, particularly corporate litigation, for the parties to have to review in one form or another 1 million, 2 million, 3 million emails and supporting Word or other documents, Excel spreadsheets, and the like. And part of the problem is because in the good old days when everything was on paper, people tended to have nice, neat files. You know, not always, but if there was the XYZ contract, there would be a central file about the XYZ contract. Then there might be some other information in finance or accounting. Now there is some of that, but as information has gone electronic, people seem to think, well, when we need it, we'll find it, you know, somehow through the digital stream. And so things, particularly unstructured data like email, tend to just proliferate. And with people using email, what used to be a phone conversation or a water cooler conversation or walking down the hall now involves an email, a response to the email, respond all, proliferation, et cetera, et cetera. So corporate data and even individuals' data when they're involved in litigation seems to be growing exponentially. And if companies don't get a handle on their data, then they are hit with staggering costs when it comes time to go through e.Discovery, at least in the United States. I mean, that's my perspective. I know somewhat about the British system. I know a little less about the Australian system. Certainly on the continent, they don't have discovery, but in those areas where there is discovery, it's involving bigger and bigger amounts of data for the same size lawsuit. And 5 years from now, if people don't get their digital data in order, it's going to be impossible.
Jason, I don't know whether you have any examples of this, but it might also be interesting to look at this question from the perspective of class actions. We have them here in Australia, but I suspect not to the same degree as you do in America.
Well, we are a very litigious nation, so we have lots of class actions and we have lots of lawsuits. And that makes firms like the one that I work in, Drinker Biddle, very happy. Let me step back a moment, and because I don't want to go too far into the panel discussion tonight without sort of a common baseline understanding of the term information governance. And then I want to say something about big data, because we've touched on that. And the one takeaway for everyone here is that I've had the privilege of co-chairing something called the Sedona Conference in the past, which is a think tank. Judge Peck and I are associated with it and worked very hard over the last decade to try to inform the legal profession in the U.S. The Sedona Conference Commentary on Information Governance has a definition of information governance, which I think is, one could say in one sentence, and it is worth just repeating here, that information governance encompasses and reconciles the various legal and compliance requirements and risks addressed by different information-focused disciplines, such as records and information management, data privacy, information security, and e-discovery. The first point I would say is that information governance is not just records management on steroids. There is a need for corporations around the world, given that data is doubling every 18 months, to get a handle on their internal data organization. And unfortunately, there is a great deal of chaos out there, as we know, with shared drives and with legacy systems that, with proprietary formats, and difficulties in searching, difficulties in visibility to the data. Now, the term big data has come up already, and I agree with Judge Peck that big means lots of data, and I've said the data volumes are exploding. But there's also something that is quite intriguing and important that has emerged, and Judge Peck is perhaps too modest to mention it himself as a lead into this discussion, but I'm going to force the issue by saying that Judge Peck issued a landmark decision in 2012 in the United States called De Silva Moore versus Publicis Group. And what has happened in the United States, and what's important as a discussion point for e-discovery and information governance, is that what Judge Peck said is that in his courtroom, he recognized that predictive coding and other kinds of related analytics in the e-discovery space was something that was a reasonable approach in e-discovery. And I will let Judge Peck describe that in greater detail. But the fact is that we are at a moment here which is of value to corporations across the world, which is that coming out of e-discovery, we know that we can save tremendous amounts of dollars in litigation using smarter methods, more analytics in the space than what was traditionally manual search or keyword searching. And we could talk about that some more. But we can apply what is happening in courts like Judge Peck's and others around in the United States, and over the next decade around the world, to have a broader conversation about information governance, to think holistically about data. And what I'd like to circle back in, because I'm not going to treat this as an hour soliloquy here, what I'd like to get into is that there are ways for every lawyer in this room at your law firm to add value to the clients that you serve by applying the kind of algorithms that is being talked about in the United States in predictive coding and with knowledge in Australia as well, in a larger discussion across a spectrum of issues involving both information management and business intelligence. And so I hope that we can have time to get into this, because it's a really important moment for everyone here to realize what value we have as lawyers talking to the solution providers and understanding what's going on with analytics.
Well, I think that's one of the things that, just in the context of litigation, those decisions are so thrashed out under the microscope of, both sides of counsel in front of the judges, that I think it's kind of a toss-up from sort of a pure technology perspective. And again, I think you can debate it. One of the things I really wanted to stress is that in the light of litigation, using predictive coding has a very serious implication, because essentially you're deciding not to look at documents based off technology. But if you take that same methodology and you apply it to information governance, and I think this is something that Jason was going to, is that outside the scope of litigation, organizations still have millions, if not billions, of documents that are out there. And if you're willing to accept a computer making these types of classifications as part of litigation, when it is under the scrutiny of, basically everyone, why not apply that same technology across an information governance challenge? Where I have, huge volumes of information, and either potentially I'm trying to classify them as records. I can take that same notion of, I have records in my records management system. Let me use those as my seed set. Let me then apply that same technology methodology across my other documents. So again, as an industry, we've gotten very focused on basically auto classification or predictive coding. So at Nuix we call it auto classification, because I'm a firm believer that there's a much broader use case for that technology. Judge Peck referenced spam filters. Why not leverage that same technique across everything that you're doing? And instead of producing purely documents that have gone through the predictive coding process, why not cook that into every single one of your discovery practices? If the cost of it has become incredibly affordable, why not have processes by which you're, in essence, seeding tags? You're not necessarily submitting that information directly to the courts, but leverage the technology to reduce costs, save time, and basically just populate potential tags as you go. So again, as a technologist on this, I think there's a tremendous potential to save time and cost and apply these same skills outside of eDiscovery to the information governance problem.
Yeah, it's interesting. I was just thinking as both Jason and Stephen were talking then. I think from our experience that there's a lot of companies are still putting the whole records management issue into the realm of IT. So, that's all computer stuff, that's all emails and things that are stored on computer systems, and therefore, as Jason mentioned, because it falls to the CIO and they're busy just trying to make sure that everything works, and in busy organisation, you're literally caught up in the day-to-day operations of the firm rather than stopping and thinking, well, how do we ensure that our data's managed? And that then leads to the issue of, the records not being appropriately managed. It doesn't become a business problem, which it should be, and organisations are getting caught out all the time. And it just made me think of a question, and I know you're wanting to ask a question, but Stephen, just from that project that you did, I guess, what are the lessons learnt? I mean, that was a huge project, but obviously the team came together and were able to get a solution to the problem. So how can that be condensed and bottled up and brought down to smaller organisations who don't have the wherewithal to stop and think about these issues? I mean, are there sort of 10 dot points that can be taken away from that are lessons learnt?
This gray hair, this gray hair, this gray hair. No, I mean, it really, I guess it's when you look at the problem, it's deciding to make and try to achieve manageable goals, and choose things in which you can get agreement on. So even though this was a massive project, we basically discussed, okay, what's some common ground between IT and legal? One was time. We could agree that something that had been kept for 10 years, that was basically just kept for 10 years for no good reason, that we could dispose of that content. That absent any, all the legal hold searches were run, so they'd met their preservation obligations. There was no need to keep that information anymore. So something along the lines of dates. Deduplication, binary duplicate items. Why do I have 400 copies of the same email? We can eliminate those. And those sort of like really simple, low-hanging fruit, we stopped there. We had grandiose ideas, and we talked about using predictive coding, and we talked about doing keyword searches, and we did subject frequency analysis, and we found that there were millions of system alerts that had been put into this email archive. And quite frankly, the line was drawn in the sand. That is, the moment that you crossed from basic metadata that sort of legal could easily get behind, it started to become subjective, and people started to get squirmy.
Yeah, lawyers particularly, yeah.
Precisely. So, thinking about it at a smaller scale, I think the biggest recommendation is to target a project in which you can have some success. So pick a file share, pick something that is manageable, and you can show the real return on that. Otherwise, if you pick too big of a project, too many people get involved, too much opinion, and it never happens. And that's how most of these projects basically die on the vine. So that sort of force of will, showing measurable success, even if it's small, whets people's appetite. I think if you can get an attorney, quite frankly, to agree to delete one thing, you can get them to start to delete the next thing. And you basically warm them up to the process. I mean, the analogy that one of the attorneys on the team used was they started out by disposing of hard drives. They said, okay, if this hard drive is broken, like it will not spin up, we will not be able to get data off it, can we get rid of these? And they were like, okay, yes. Okay, well, so the broken ones we can get rid of. And they literally walked them down the process of getting someone comfortable with the idea of disposing of some data, and they basically worked their way through it. So, I mean, it's pretty much achieve a manageable, or, choose an achievable goal, and then stick to it.
On my part, I'd like to thank all of our panellists, particularly our guests from overseas, and thank you.
And thank you very much to Justice Beazley for chairing the event tonight. We appreciate you coming along.